नमस्कार। जाओ वर्सेस फाओ इनकम टैक्स एक्ट में 148 रीअसेसमेंट प्रोसीडिंग्स में ये कंट्रोवर्सी बहुत दिनों से चल रही है। आफ्टर इंट्रोडक्शन ऑफ scheme notified under section 151 capital A, whether notice under section 148 can be issued by the jurisdictional assessing officer, ये इशू है। इस स्कीम में कहा कि ये जो नोटिस अंडर सेक्शन 148 है, इट हैज टू बी इशूड बाय एनएफएसी इन अ फेसलेस मैनर। ये स्कीम नोटिफाई हुई 28 मार्च 2022 को। 28 मार्च 2022 के बाद जितने भी नोटिसेस अंडर सेक्शन 148 इश्यू हुए, which were issued by the jurisdictional assessing officer, those notices were challenged before several high courts. In most of the high courts, wires of those notices for assumption of jurisdiction were challenged. और बहुत सारे कोर्ट जो है, they have ruled in favor of the SSC that after introduction of scheme notified under section 151 capital A, jurisdictional assessing officer did not have any power to issue the notice under section 148, and the notice could have been issued by in the faceless manner by the faceless officer. Now our finance minister Shrimati Nirmala Sitharaman ji has intervened by introduction of new section 147 capital A for concluding the entire controversy in favor of the executive, in favor of the government. Now, what this proposed section 147 do is, it creates a deeming fiction retrospectively with effect from 28th March 2022, and this section says, notwithstanding anything contained in any judgment or any order of the court or any scheme notified in section 151A or section 151A, जो jurisdictional assessing officer है, he had the power to issue notices under section 148 of the act. ये इनकम टैक्स एक्ट में रेट्रोस्पेक्टिव अमेंडमेंट आना कोई नई बात नहीं है, लेकिन जब से ये प्रेजेंट गवर्नमेंट आई, प्रेजेंट गवर्नमेंट अंडर द लीडरशिप ऑफ our as a tax professional, I remember that Vodafone controversy 2012 finance bill was presented by Pranab Mukherjee ji, Honorable Pranab Mukherjee ji, और उस समय एक रेट्रोस्पेक्टिव अमेंडमेंट लेकर आए थे। उसके बाद देयर वाज सो मच ह्यू एंड क्राई इन द इंटरनेशनल फ्रेटर्निटी, और उसके बाद जब प्रेजेंट गवर्नमेंट एनडीए की गवर्नमेंट आई, तो 2014 का फाइनेंस बिल जब हमारे फाइनेंस मिनिस्टर श्री ऑनरेबल श्री अरुण जेटली साहब ने प्रेजेंट किया, तो ही मेड ए कमिटमेंट इन द बजट स्पीच कि दिस गवर्नमेंट विल नॉट रिसॉर्ट टू रेट्रोस्पेक्टिव अमेंडमेंट्स। और 2015 में भी हमारे प्रधानमंत्री जी ने ये प्रॉमिस किया इंटरनेशनल मीडिया के सामने that this government will not resort to retrospective amendment and will give certainty to the tax laws. लेकिन after introduction of 148 regime in the year 2021, we have seen immense amount of litigation which has taken place to challenge this regime of section 148. And this immense litigation has involved a lot of time of the court, advocates, professionals, SSC, and as government as well. And after fierce litigation, courts have decided something or mandated something. And now to bring an amendment to counter those interpretations given by the court, and that too retrospectively, whether this amendment is constitutionally vulnerable, whether this amendment will pass the test of thin line of demarcation of separation of power between the executive and the judiciary. And there is a question whether inefficiency of the executive can be converted into a law by the legislature, and that to overreach the power of the judiciary. So this amendment, which is proposed retrospectively, is we have to see whether this is constitutionally vulnerable, whether this will be able to pass the test of constitution. And one more thing, This amendment, which is introduced with the purpose of ending the litigation and bringing an end to the litigation, whether this will give rise to another round of litigation before the courts, and whether this section 147 capital A in the present form, whether it will be tested with the constitutional courts under Article 32 and 226 of Constitution of India. We have to see that. So, with this, friends, this is a Pandora box of fresh round of litigation, which may be introduced by this new section 147, capital A of the Act. Thank you.